Myself is Dr. Jinesh Soni. I am an advocate and a corporate lawyer. In today's class, we will study about the strategies to be adopted while contesting a case under Prevention of Corruption Act. Usually, I observe that whenever we are having a charge sheet under Prevention of Corruption Act, we got tense or troubled, but we are not willing to contest the case. We observe that any advocate or a lawyer could help us in the matter to vindicate it properly. But in fact, I want to submit that there is no one in this world who could help you except yourself. For this, despite of having a tense attitude, you have to read the entire file. And it is not a tough task. Basically, we have to consider on those points which are important for us so that we could easily submit our stand before the competent court. To read a charge sheet concerning with offences under Prevention of Corruption Act, first of all, we have to divide the charge sheet in four parts. Part number A, B, C, and D. In part number A, we have to discuss the point of demand. In part number B, we have to discuss the facts regarding pre-trial proceeding. In part number C, we have to discuss the facts regarding the trial proceeding and the proceeding subsequent thereto. In part number D, we have to discuss the statement of the complainant and the witnesses recorded as per the protocol of section 161 of CRPC or 180 of BNSS. Read with section 164 of CRPC or 183 of BNSS if any, along with the sanction order. And apart from that, we have to observe the proceeding conducted by the inspector while arriving on the conclusion. Now we have to observe the competency of investigating authority in the light of section 17 subclause C of PC Act. Read with section 26 of BNSS. That is quite important to be succeeded. We are having multiple tools by the virtue of which we could easily defeat the prosecution, and these tools are available in Bharatiya Sakshya Adhiniyam or Indian Evidence Act. So as far as part number A is concerned, we have to observe the demand, in which manner it has been raised. For this, we have to read the report and have to find out the motive of crime, the basis of demand. If the basis is inconsistent with the facts of the transcription, then we could have the benefit as per guidelines of Honorable Karnataka High Court judgment, that is Mahesh PS versus State of Karnataka. Judgment date is 24th of May 2023. Apart from that, we have to observe whether any AI tool is used or not. Sometimes there might be a possibility that certain part of audio or video is transcripted. If it is done, then we could take the help of cyber expert. And apart from that, sometimes they used to mention the voice is not clear, but despite of that, voice is clear. And inter alia, it is submitting the defense point in your favor. So, looking to all circumstances, we are supposed to work on the demand. Number two, its genuineness, and apart from that, the consistency and corroboration in the facts concerning with demand. If you find the answer in negative, then we could easily contest the case on that point. In part number B, we have to observe the proceedings conducted concerning the pre-trial. For this, we have to observe in what positions the articles are kept, how they are consumed. So basically, we have to emphasize on the Malkhana register and the entries of Malkhana. In part number C, means the trial proceeding, we have to observe in which manner the recovery was made. Number two, if the money is thrusted, in which manner they are thrusted. So we have to find out every possible way to raise a probable defense concerning the acceptance recovery so that we could be succeeded. And apart from that, we have to observe the transcription of demand made during the trial proceedings. If all the scenarios are inconsistent, in that scenario we could be benefited. And apart from that, in the last segment, we have to observe about the testimonies of the witnesses, whether they are recorded proximately or at a remote time. If there is a delay, it is not explained in that scenario, we could have the benefit. In the light of judgment of Honorable Supreme Court, that is 2016 Criminal Law Reporter, Supreme Court, page 1131. In addition to this, we have to observe whether sanction order is as per norms or not, and whether there is due compliance of judgment of Honorable Supreme Court, that is CBI versus Ashok Kumar Agarwal. Judgment date is 31st of October 2013. In addition to this, we have to observe the due compliances of guidelines of Honorable Supreme Court, that is Ram Singh versus Ram Singh, AIR 1986, Supreme Court, page number 3, concerning the electronic record. So in this way, we could easily have the proper strategy concerning the evidences, and on the basis of evidences in rebuttal, we could submit our strong point, our strong stand before the court to ensure the acquittal. I want to clarify that we are having the recent judgment of Honorable Supreme Court, that is Madan Lal versus State of Rajasthan. In that case, all the points submitted by me earlier had been discussed. In that case, the accused was prosecuted and charge sheeted as per Section 7, 13 of PC Act. He was convicted by the concerned trial court, and even Honorable High Court upheld the conviction. He submitted the petition before Honorable Supreme Court for remedy. His submission was that the complainant concocted a story, in consequence of which I was falsely implicated, but the concerned trial court and concerned High Court totally failed to consider my submissions. His submission was that the complainant is having a story that he has applied to have the license to deal in food grains and edible oils. In consequence of processing, the concerned inspector inspected the premises and he raised a demand. In the meanwhile, he met with the concerned DSO, he also raised a demand, and finally he submitted a report, and the concerned officials got trapped. The prime attack of defense was that the demand is not proved. Demand is required to be proved. In absence of demand, even though there is a recovery and acceptance, the same could not connect the accused with the crime. Number 2, the defense submitted that there is inconsistency in the statement or testimonies of the witnesses, and that's why the concerned complainant set up a different version at different place. So such inconsistency should be considered against the prosecution and adverse inference is to be drawn. He submitted that the money is not accepted, but the concerned complainant inter alia tried its best to thrust the money. In the meanwhile, the team had come, and finally the concerned accused was compelled to pick up the currency note and to count the same, in consequence of which phenolphthalein powder had been shifted, and finally the color test was positive. Such explanations are required to be given to avoid the negative inference of Section 114, subclause Z of Indian Evidence Act. Apart from that, he submitted that there is a much more difference in testimony of complainant concerning demand, because in the report he submitted that demand is rupees 200, but in the court statement he was not sure what amount was demanded. It might be 200 or 400, or he submitted certain statement which were quite inconsistent with the previous statement submitted by him. Apart from that, there is no independent corroboration of the alleged demand. Material witnesses turned hostile. So looking into the facts and circumstances, the court observed that due to inconsistency, omissions and contradictions and lack of corroborations, the demand is not proved. So finally, the accused got acquitted. So we could say that the demand plays an important role. To suspect the demand, we may rely on the 5 important strands. To sustain the non-existence of demand, we could rely on the 5 important points. Number 1, there is inconsistency in the statement of witnesses. Number 2, AI tool might be used. Number 3, as per the FSL report, voice is probable. Number 4, there is lot of omissions or additions in the testimonies which makes the case highly doubtful. And number 5, there is no pendency of work. And as we know that pendency of work is one of the most important criteria to explain the motive in explain of both the parameter. It could not be said that demand is genuine. For this, we may rely on judgment of Honorable Jharkhand High Court, that is Pramod Kumar versus State of Jharkhand. Judgment date is 16th of November 2022. So I think that I am totally able to convey all of you the recent judgment of Honorable Supreme Court concerning demand, acceptance, recovery. So whenever you are having the trouble, you have to emphasize on the said principle and have to study the file in the manner inter alia submitted by me. If you are having any question, you may put the same in the comment box. I will try my best to answer the same. See you in the next video. Till then, Jai Hind, Jai Bharat.